Yeah, no, we'll do. I gotta reorient myself. Yeah. All right. Before we go on the record, just kind of see where we are, kind of assess what we can still achieve today. Apologies, everyone, to keep you waiting. We've been taking pleas since 9 a.m. and the day has gotten away from us. So unless anyone wanted to jump in the back of that line, let's see where we are. I know we had scheduled most of Mr. Floyd's motions today. I think it's safe to say we're not going to reach those. But the priority was to try and get some clarity on the motion to quash. So I want to at least start that. I don't know how far we'll get because I think it's probably going to require much in the way of evidence. And then Mr. Eastman had asked to kind of be a drop-in addition to the calendar saying he wanted to make argument. Was it just on the special demur to count one?
That's correct, Your Honor.
Okay.
And as I said, no more than 10 to 15 minutes.
Okay. And I think that's all the state is here for, was just that sole motion. They hadn't filed a motion to intervene or quash on behalf of the clerk. So that's really the only reason y'all are here, right? So maybe it makes sense to me then. We start with Mr. Eastman and then we'll transition into the motion to quash and see how far we get. Do we have, I don't know if I see the county attorney from the clerk's office. Do we have the clerk's office? Oh, there you are. Okay. Everything good? All right. Okay, well then with that, we'll go on the record. Let's start with State versus John Eastman. And I think the first appearance by counsel on behalf of Mr. Eastman. And so let's do this first. Let's have everyone identify themselves for the record. And so who's going to be arguing on behalf of the state today?
Judge, Mr. Floyd will be arguing on behalf of the state.
All right, welcome back, Mr. Floyd. And on behalf of Mr. Eastman, who do we have for the record?
Buddy Parker, Your Honor.
Okay, welcome, Mr. Parker. And I note that Mr. Eastman is here as well. So, Mr. Parker, your motion, sir.
Thank you very much, Your Honor. At the outset, let me just identify for the record that often Mr. Eastman is referred to as Dr. Eastman. He holds a PhD in political science. It's not a reference to a Juris Doctorate. And since that degree is often referred to in our country under custom and practice as a doctoral prefix to the name, that's the explanation for Dr. Eastman. And I wanted to put that on the record. We're here today briefly to supplement, if you will, not to re-argue, the written motion filed on behalf of Dr. Eastman for special demurral on count one. I'd like to say at the outset that we would like to adopt the argument made by Amanda Clark Palmer last Friday on the very issue that we raised in our special demurral as well, and on the supplemental brief that was filed on behalf of Mr. Smith by the Garland Samuel Loeb firm on this special issue as well.
And y'all adopted by way of formal filing as well?
Well, I'll be glad to do that.
Okay.
We had not, the supplemental brief was not, did not come in before the 8th of January, so we haven't filed anything.
But their initial motion that kicked off this whole thing, you've adopted that, right?
Right.
Okay, I think that's sufficient.
That's all. I just wanted to make it clear on the record. The principal two issues raised in our special demurral was that, and I argue it as if it were federally like a bill of particulars, that the indictment does not describe the connections or relationships among the defendants with the enterprise, nor does it describe anywhere how the members of the enterprise function as a continuing unit. Now, I know the state has filed its response this morning to our pleading, and so the issues are pretty well joined. What I wanted to bring to the court's attention, if I may get my reading glasses so I don't make any further errors. So I'm referencing to page 6 of the state's pleading this morning, in which they point out that the overt acts, including those that constitute racketeering activity committed by the defendants, were designed and intended to further the objective of unlawfully changing the outcome of the election in favor of Trump. And so with that as their North Star, it would appear that the allegations in the indictment, and more specifically looking at page 7, the state writes, specifically as to Eastman, the indictment alleges that he acted together with and was in regular communication with multiple co-conspirators. Eastman's activities in furtherance of the enterprise's objectives included communications to Georgia government officials, communications with conspirators in Georgia, and efforts at unlawfully changing the outcome of the election that went to the highest levels of government and involved direct coordination with defendant Trump. In that regard, it notes that Dr. Eastman at a point in time made a presentation. It was a Zoom presentation before the Georgia subcommittee of the Georgia Senate. And just focusing on that conduct, Your Honor, which was described as being collectively, allegedly, together with others at that period of time in presentations to the Georgia Senate, Dr. Eastman making false statements to the Georgia Senate. We have no indication specifically as to the alleged false statements that he made. But to the extent this has not been raised before, I wish to raise it now. Unlike under the First Amendment to the federal Constitution freedom of speech clause, we also have a clause of being able to address government for grievances. So we have yet a different type of First Amendment right being exercised by Dr. Eastman in his presentation to the Georgia State Senate. Now, whatever was said is recorded, it's evidence, it's going to be played, so it is what it is. But in the indictment, we have on page 16, paragraph 1, the grand jury alleges that members of the enterprise corruptly solicited Georgia legislators instead to unlawfully appoint their own presidential legislators for the purpose of casting electoral votes for Donald Trump. The word corruptly is an interesting word because it would appear to connote a degree of mens rea or specific intent. What is it that makes what was said corrupt? Was it something in the words themselves? We don't know. This is where I'm coming at from the work from the special demurrer. We don't know what it is the state's theory of the underlying nature, whether by direct, it should be by direct quotes, taken in the full context of the presentation, that makes the words of Dr. Eastman corruptly stated. Likewise, and more particularly because this is more unique to Dr. Eastman, their allegations and in its response to the special mirror motion, the state makes a point to bring up the various meetings Dr. Eastman had with Vice President Mike Pence, some involving then President Trump as well. And in the indictment, referring to the same phraseology on page 18, paragraph 6, it identifies that members, quote, members of the enterprise, including several of the defendants, corruptly solicited the Vice President of the United States to violate the United States Constitution and federal law by unlawfully rejecting electoral college votes cast in Fulton County, Georgia, by duly elected and qualified presidential electors from Georgia. Members of the enterprise also corruptly solicited the vice president to reject votes cast by the duly elected and qualified presidential electors from several other states. Again, what is it within the language of the communication allegedly made by Dr. Eastman or within his presence that indicates what is corrupt about the language? What is it that do we refer back to, or are we referred back to the overall so-called objective of the racketeering, of the alleged objective of the racketeering activity in the enterprise through the acts of racketeering? Or are we just to anticipate that what corruptly will be defined as is whatever the state just simply argues it to be? It's a violation, ipso facto, the election had been certified, therefore any communication contrary to the certification of the Biden electors, ipso facto makes it corrupt.
Is it so much the word corrupt, or it's just that you believe that there should be a more specific reference to exactly the content of the speech? So, for example, that it just said illegally solicited. Again, maybe we'll hear exactly where the word corrupt was used, if that's more of a term of art or what. But is it the corruption that's causing the confusion in your argument, or is it more that just they haven't put in the quote, this is what he said on this particular
I'm
day?
looking for more detail specifically. I'm looking for more detail. Why? Because the issue is going to arise at the time of the resting of the state's case in chief, whether or not, based on the terms and language of this indictment, the state has met its burden, or the case can proceed to a jury, if you will. So I don't have any hesitation in telling the court this is where we're coming from. More detail. And that essentially is our argument. And I don't certainly given the amount of time the court has had to spend it already with the adoption of the previous arguments, I have nothing further to say at this time, Your Honor.
Well, I'm curious. I know that the filed motion focused more on kind of the Boyle factors, kind of identifying how this enterprise is associated with what they did, kind of wanting more detail about the enterprise. I'm just curious, have you found an indictment, maybe post-Boyle, that you think satisfies that, in your opinion, or that a court said satisfied it? And no one's actually handed me an indictment that says this is a good post-Boyle indictment, other than this one, which the state is saying is. I'm just curious.
I first, to answer directly, I have not yet tried to make that search because I think it's a case-by-case specific analysis. Clearly, in an association, in fact, enterprise, there has to be some delineation as to the relationship among the conspirators in terms of their role. Now, from a federal racketeering point of view, you can't have, a person who lacks managerial capacity or some level of decision-making authority as part of the member of the enterprise. I mean, there is some substance to each and every person's role in the Ernst v. the Supreme Court case dealing with the position of a person with some authority in the association, in fact, enterprise. The janitor is not a person who would generally be swept into the terminology of an enterprise, of an organization, is my simple point.
Okay.
But what I will be glad to do for the court is to supplement our position, answering the court's question directly.
All right. Well, I guess that, I don't know. I don't know if I'm worried I'm going down the rabbit hole on this one. What was the argument that, I know you said you wanted more information about the enterprise and each defendant's role in it, but I hadn't heard this one yet, that if they don't have some level of authority, they can't be included in the enterprise.
Well,
I don't know if that's in here.
Basic federal law. I hesitate to suggest it should be adopted by the court.
Okay. Well, I'll put it this way: if it's not in the written motions initially, I won't get there.
Okay, well, then we're not going to get there.
Okay, well, let's turn it over to Mr. Floyd, and we'll let you have the last word as well.
Good afternoon, Your Honor.
Good afternoon.
I will start where my friend Mr. Parker ended. The test he's referring to, as he said, is Reeves versus Ernst & Young. That's referred to as the operation or management test under federal law. It does not apply to Georgia law. There is a linguistic distinction. The federal statute, 18 U.S.C. 1962C, says conduct or participate in the conduct of the enterprise. The two dual use of conduct led the Supreme Court, United States Supreme Court, to conclude that that imposes some level of influence or control. Georgia says conduct or participate. Under Georgia law, participation is sufficient. There is no operation, management, or conduct requirement. This is expressly laid out in FLYOD. FAILLACE, which we've cited a number of times.
All right, fair enough. But I think because I don't think a brief has actually raised this yet or a motion, so we can.
It doesn't.
From there.
In fact, I don't think anything Mr. Parker argued was in the brief. There is no reference to petitioning for redress of grievances in the brief. There's no reference to corruptly in the brief. And he omits to address the fact that Mr. Eastman, I mean, what this has mutated into, it started out as a challenge to the Boyle factors. Let me just knock that out for a second. There are four reasons why those don't apply. First, and we've talked about this, so I'll be brief and try and avoid repeating myself. For the record, I'll adopt the same arguments we made in opposition to Ms. Palmer's motion last week, and I will do my very best not to repeat them unnecessarily. First, no Georgia court has adopted Boyle. Second, Boyle was not a conspiracy case. Boyle dealt with jury instructions after the record had been made after the trial. Third, Boyle, jury instruction case. Fourth, an enterprise is not an element of a RICO conspiracy case. We cite United States v. Applins out of the Second Circuit on that. It's in our brief. There are at least three other circuits that have reached the same conclusion. I haven't found a federal circuit that reached the opposite conclusion. So Boyle just doesn't apply. But if Boyle did, as I pointed out in earlier arguments, we trace its language exactly. So there's not a Boyle problem here. What the argument has really mutated into is the idea that we haven't said enough detail about overt acts we allege Mr. Eastman engaged in. Two flaws for that, as we've pointed out in earlier briefs, so I won't belabor it. The state isn't required to allege the details of overt acts at all. We don't have to allege elements. We don't have to get into things like corruptly, which really just means illegally in a context like this. This is just not a pleading requirement, and Dr. Eastman cites no case saying it is. The federal cases, which incidentally apply exactly the same pleading standard as the Georgia cases do when they look at special demurrers, have rejected any such requirement. And I'll give you the cites of a couple of those in a moment, but just to start with United States versus Kelly, 462 F sub 3rd 191 at 196-97, an Eastern District of New York 2020 case, so relatively fresh off the presses, expressly goes into this and says there is no requirement that an indictment allege the sub-elements of enterprise like the three Boyle factors. The federal courts have just said no, that's not a pleading requirement. It may go to whether the state has proved its case at the end, might be subject to a directed verdict motion, but it is not a pleading requirement. And there are multiple federal cases holding that. So basically what the federal courts have said is if the indictment basically explains who participated in the enterprise, what they did, describes the purpose, the means and methods, that's sufficient. An example of that is United States versus Torres, TORRES 191 F 3rd 799 and 806. That's a Seventh Circuit case. United States versus Johnson, 825 Fed Appendix 156 at 171. Fifth Circuit case, also 2020. If the indictment identifies the criminal enterprise, establishes the time in which it operated, names the co-conspirators, and lists the violations that constitute predicate offenses, and says which co-conspirator performed which act and when, that is sufficient. We've done exactly that. We charged in the language of the statute, so that satisfies 17,554, I believe it is, Your Honor. That's number one out of the gate. That's presumptively sufficient. If more detail is required, we described the enterprise, we described its objective, we described the 8 schemes that were pursued in furtherance of it, 2 of which Mr. Parker referred to. We then laid out 161 overt acts. They have the dates, they have the participants. Dr. Eastman, who is saying he can't figure out what he's charged with, at least that's what his demurrer said, we have laid out 16 overt acts, and where he acted with another person, which is the vast majority of them, we have identified who those persons were and the nature of what the communications involved. So, for example, we do refer to his representations to the Georgia Senate along with defendants Giuliani and Ellis. We refer to his email communications with defendant Shealy and unindicted co-conspirators 8 and 2. We reference him mailing a memo from defendant Chesbrough to defendant Giuliani. We reference his meeting together with Mr. Trump. Sometimes it's a telephone call, sometimes it's a face-to-face meeting. Further emails with Chesbrough and unindicted co-conspirator 3. Filing a knowingly false verified complaint together with defendant Trump here in Fulton County. Call to the Speaker of the Arizona House of Representatives soliciting him to unlawfully appoint presidential electors from Arizona. And then this all culminates in approximately 4 overt acts towards the end of the list, which directly involve meetings and communications with Vice President Pence and or Vice President Pence's Chief of Staff and Counsel, all importuning Pence directly or through his representatives to not count the electoral votes from certain states or to suspend the count on January 6th. When there was a reference to the janitor, and there actually is a federal case that does involve a janitor in the Second Circuit, and he was charged in a RICO, and the Second Circuit said, no, the janitor doesn't operate or manage, right? That case has nothing to do with this, number one, because that test doesn't apply, and number two, because janitors don't go to meetings with vice presidents and presidents. Dr. Eastman did. So we're really just getting down to, did this happen or not? And the argument that they need every detail, we've laid out, this is the meeting, this is who was there, this is when it happened, and this is what was discussed. I can't find any case that says that's not good enough. That just basically walks through it. The nexus argument, we've briefed it. It really hasn't been offered here, but you asked about indictments that were adequate. And I have a couple of references for you. First, in Georgia, and I've talked about these, so I won't belabor it, but Pasha has been cited to you many times. This is what Pasha said, and it was a RICO conspiracy indictment challenged by a special demurrer. The indictment clearly gives Pasha notice of the nature of his involvement in the conspiracy, the overt acts attributed to him as advancing the conspiracy, and the underlying predicate offenses which establish racketeering activity. Check, check, check. We have done all 3 of those. And when I say check, it's because we used Pasha, and we literally did check. Grant versus State, a case that preceded Pasha and is frequently looked to by the Georgia courts to look at the adequacy of indictments. Grant said, the indictments are in no way defective for being insufficient to support a prosecution and conviction. The requisite predicate acts and enterprises comprising the charges against appellants are precisely described and named in each instance. No greater detail was required to allege the RICO offense under Georgia law.
And Mr. Floyd, I think what I was getting at
Yeah.
is that they'll, say we've reviewed it, we pronounced it, maybe they'll quote portions, but a lot of times they won't do it at length, right? Probably because these indictments are so long. So I just wonder if you've ever pulled any of them, and we could actually have that as an attached exhibit by way of direct comparison to see what the Court of
Right.
Appeals was looking at.
I will tell Your Honor, in response to your question, we pulled quite a few federal indictments, and I recall reading at least 20. And I would be happy to provide examples if those would be useful to the court. They're under federal law, they're not under Georgia law, but the federal sufficiency standard is functionally the same.
Or, for example, these Georgia cases that are cited to so frequently, like Pasha and some of those others. I don't know if those are indictments we can get our hands on. Just that would be interesting by way of comparison to be actually seeing what the Court of Appeals and the Supreme Court was looking at when they said this is sufficient.
I'm happy to try that. Yes, I hadn't done it before because I don't think I've encountered a court that would have appreciated my attaching that in the past. They tend to be a little weighty.
But anyhow, just
No, it's an
just a thought.
interesting point. And when I say the federal standard is the same, one of the things I noticed and one of my colleagues noticed is we kept going through the formulation of how the Georgia courts state the pleading standards. And I recognized that this sounded very much like federal law, but the Georgia courts generally were not citing the federal cases. There was a time when Georgia appellate courts often did not cite the United States Supreme Court, even if they were using the same language. But if you look at Cochran versus State, 157 U.S. 286 at 290, in 1895 case, you'll see the standard is expressed in almost exactly the way the Georgia courts put it now. And that continues through a case called Hamling versus United States 418 U.S. 87 at 117, a 1974 case. It really is the same language, and that really is what the federal courts are following here. That's, as I said, I've cited you a number of cases. I'll give you just one more before I sit down. And actually, I mentioned this in Johnson. The court went through it, and this was a challenge to an association in fact enterprise that was a street gang called the Block Boys, and they said you haven't told us enough. That count was 15 pages. Ours is 71. Court said it was adequate. It identifies the Block Boys as the criminal enterprise, establishes the time period during which they operated, named the co-conspirators, listed the violations that constituted predicates, said who performed each act and the date it was performed. That's precisely what we've done. There was an argument in that case that the indictment failed because it didn't tell the defendant exactly what activities conducted were part of the conspiracy's agreement. The court said this court has not required that a RICO indictment include such specificity, nor does the Constitution. We refuse to adopt Durden's offbeat position, was the language the Fifth Circuit used to dismiss that. So the argument that Dr. Eastman started making in his briefs fails. It doesn't work on Nexus, and it doesn't work on Boyle for the reasons I've said. The argument that he makes today is not in his briefs.
In recognizing that, and any initial reactions, just offhand, to this idea of?
Well, the petition for right of grievance, or the petition, this is an issue that has, people have alluded to it. Number one, it's not really his grievance. He's not the candidate. But number two, one thing that petitioning does not permit is any sort of lie, any sort of false statement. There is no protection for that. One doesn't get to speak to governmental officials, say something that's false, and then say, oh, but that's okay, I was petitioning for redress of grievances. The conversations with Vice President Pence and his closest advisors aren't for redress of grievances. They are asking him to break the law. And in fact, in one of the overt acts we set forth, we actually quote a communication from Dr. Eastman in which he says, and I am paraphrasing, these are not the exact words. He basically says, I'm asking you to violate the law one more time. He makes it abundantly clear. His position is the law has been violated. And then he is asking that it be violated again. That is not asking for a redress of grievances. That is asking someone to violate the law. Those are not the same things, and there is no protection for that sort of behavior. The last point is, as Pasha, Haley, and other cases that I have cited to you on numerous occasions make clear, the only argument that's been set forth here today goes to overt acts alleged against Dr. Eastman. That leaves 142, I believe, alleged against others. Under Pasha, he's responsible for all of those, and only one is sufficient to make out a RICO conspiracy violation under the express language of 1614-4C. And so even if he was right, it wouldn't matter. Thank you.
Okay, thank you, Mr. Floyd. Mr. Parker, any final thoughts?
Just a few. I believe, although my good friend, Mr. Floyd, said he was paraphrasing Dr. Eastman in reference to a conversation with the Vice President. As I understand the conversation, Dr. Eastman had expressed his opinion that the Electoral Count Act itself was unconstitutional. And that was the reference to violating the law he was referring to, not complying with what he views from his perspective, the Electoral Count Act as being an unconstitutional act passed by Congress. I think what Mr. Floyd, on behalf of the state, really has crystallized in the argument, and it is going to come down to this. Just what are the facts when the state's put forth its evidence? I will acknowledge that what he has said, as a matter of law, by and large, is correct. And I stood here and I say to the court, I will be more than glad to join in with him in providing a joint appendix on indictments. We've worked together over the years. Many times we can work together in providing to the court those indictments that Mr. Floyd has identified that answer the court's or provide some insight for the court as to what is sufficient in the details as far as the allegations go. At the end of the day, it's going to be whether or not the state has met its burden in its proof at the trial compared to the allegations in the indictment. And so I agree to that. And with those words, I have nothing further than to say, Your Honor.
All right, thank you, Mr. Parker. Since we have you here, I believe this was the only...
And one thing,
Sure thing, Mr. Floyd.
the specific act, so we don't have to guess about what I was talking about, the specific act is 141, and I don't need to belabor what it says. The court can look at it itself. The language is quoted right there.
Okay.
For ease of reference, Your Honor. That's all.
All right, well, while we have you here, Mr. Parker, and as well as your client, I believe other than adopted motions, this was the only other substantive one that we needed to address before, you know, a case management conference whenever that day arrives.
That's correct. We did file what I referred to as a placeholder Fourth Amendment motion dealing with two different, one, a search and seizure of Dr. Eastman's cell phone by the FBI. I believe that occurred in New Mexico. Is that correct? Yes, in New Mexico.
Right. And I'm remembering that one. I wonder if, since we're all here in the States here, maybe we could provide some clarity on that instead of having.
Yeah, because we haven't seen yet anything in discovery that would appear to come from that source. If the state does have it and they intend to use it, then that's an issue we've sought to preserve.
Sure. Well, let's thank you for reminding me of that. Let's see, maybe we can even address that today. Just to the state generally, do you recall the preliminary kind of placeholder motion to suppress on the cell phone evidence? State have a position on that?
Judge, we haven't provided it because we don't have it.
And if does the state have any leads or intentions or idea of where that could be, or if they would obtain it? At this point?
At this point, we don't.
All right. If that were to change, that would be something you'd have to disclose to the defense, would you not?
Yes, sir.
All right. So.
And then the other one dealt with the litigation in federal court in California over the Chapman University files of Dr. Eastman. There are numerous emails. Some of those did make their way to the January 6th committee, which now have been disclosed, but many did not. And the reason we raised that as a placeholder is that the federal court in the California litigation, one, found Dr. Eastman had standing on as to those communications, and two, required that before any be disclosed to the J6 committee, they be reviewed by a taint team for attorney-client communications and whatnot, because that was, even though on some attorney-client communications he found the crime fraud exception, the court, the district judge, did not make a across-the-board ruling on all communications that the crime fraud exception applied. So Dr. Eastman, licensed attorney, is still asserting that issue should the state have any material that came forth from that source.
Okay. All right. And so I'll put that same question to the state, but first, just again, as a matter of housekeeping, are we all on the same page that as it relates to the phone issue raised by Mr. Parker, that's effectively moot or not right at this point? I guess, Mr. Parker, I'll put that on you since it was your motion. Based on what you've heard the state say, is there anything to handle?
Nothing, what I've heard the state say is they have no material from the cell phone of Dr. Eastman that was seized by the FBI.
Right. And per our standing order, within 5 days of them obtaining any new evidence that they would intend to introduce at trial, that's supposed to make its way into your hands. All right, so that we should know if that ever comes up. All right.
I heard that.
Okay, so let's move on then. He raised the issue of some emails that were seized by the FBI at some point. Is that also something, it sounds like it hasn't made its way into discovery, or has it?
We haven't seen any documents that reflect the bait stamp of that Dr. Eastman uniquely placed on the Chapman University document, or that work. I don't know whether he did it, but someone did it. It's just that emanates from his employment at Chapman using a computer they owned and controlled that contained what the federal court found to be clearly attorney-client communications that Dr. Eastman had standing to assert the privilege over. And so in the federal court order, were we to have to litigate this issue, which we would provide, to prove that the material had to be reviewed by a taint team before it could be disclosed. And so until we know that it's been disclosed and the state has it and the state intends to use it, we have no ability to litigate further.
Okay, turning to the state. Does this ring a bell?
It does, Judge. We've disclosed everything that we have, but we do have a search warrant that relates to that. That's with the filter team now.
This is the issue. The search warrant came from a superior court judge of this court we haven't litigated anything because let's set aside the issue of the extraterritorial authority of this court to issue a search warrant for materials in the state of California. You know, this search warrant from this court cannot obviate and supersede a United States District Court's order as to how that material must be handled.
Okay, so I'm still trying to get up to speed on this and see where we are. Y'all are ahead of me because I don't know what's in discovery. So it sounds like the evidence that you're saying the state may introduce, they have actually got with a filter team right now pursuant to a search warrant obtained by a judge in Fulton County. Well, I don't think I signed that. You'd have to remind me. And you're still waiting on the results of that.
Yes, sir.
Do you have a time frame for that?
The last conversation that we had with the filter team judge, he had not gotten to it yet. But we had some indication that they would make their way through any documents that they would have within a 3-week period. We can follow up.
All right, so there's a possibility the filter team gets through it. They disclose to you that there's nothing matching the criteria, and so there's really nothing that needs to be suppressed because you don't have anything, right?
Yes.
But in 3 weeks, maybe they do give you something that's exactly along the lines of what Mr. Parker is identifying as, in his contention, having some legal issues that we need to sort through?
Yes.
Okay. All right, so then it sounds like we'll have a better idea of that later next month and whether we need to come back on an evidentiary hearing on that. And once we've identified that, Mr. Parker, if you could just, particularize your motion and supplement it, and we'll get it scheduled.
Thank you very much, Your Honor.
Okay. Good to know. And if after a month you haven't heard anything from the state or the filter team, let's ask for an update from the state and try to hold them to that deadline.
We'll be glad to do that, Your Honor.
Okay. Was there anything else?
Nothing further on behalf of Dr. Eastman.
Okay. All right. Well, is there anything else from the state then?
Nothing good.
All right. And I think there'd been some other attorneys just generally jumping on the Zoom. They weren't noticed to be arguing on anything, but I'll kind of open the floor to any other business since we have this state here. Not hearing anything. We'll transition over to Mr. Floyd. Thank you all.
Thank you, Your Honor.
Let's transition over. Same case number, but this is State versus Harrison Floyd, and we are back together from the last time we had a hearing on this, I believe was in November, if I'm not mistaken. And this is on the motions to quash, as well as tangentially the motion to unseal, I believe, the election materials filed back in September. And let me just kind of try to lay out where we are, and I'll let the parties jump in to supplement as they see it. But I believe where we had left it is we had heard some initial argument from on behalf of the clerk of Superior Court and on behalf of Fulton County Board of Elections that not only in their contention were these materials not relevant, but that it would be unduly oppressive or burdensome to produce them. And so I took under the advisement the relevance issue, and I think that I don't know if that's necessarily something we need to get into further today, but the overriding focus was that exactly what it would take to produce these materials. And after that hearing back in November, we had Mr. Floyd's team come back with an amended subpoena request. Was that ever made a part of the record? Well, actually, first let me do this. We need to identify counsel for the record and waive your client's presence.
Good afternoon, Your Honor. Christopher Kachuroff for Mr. Floyd, co-counsel.
Todd Harding, Your Honor.
Aaron McCullough, Your Honor.
And Mr. Floyd has given you his express permission to proceed without him?
Yes, sir, he has.
All right. And on behalf of the county?
Good afternoon, Judge. Chad Alexis on behalf of the clerk.
Okay. And Mr. Alexis, just for the benefit of our court reporter, if you could really make sure to speak up and into a microphone. Medically, are you able to proceed today?
I believe so, Judge.
Okay. All right. And who else do we have?
David Lohman, Your Honor.
Can you spell that for the court reporter?
Last name is Lohman, L-O-W-M-A-N. First name David.
All right. Thank you. Okay. And so back to Floyd's team here. Did we ever make the amended subpoena part of the record, or has it been up to this point? Just want to make sure everything's complete.
Not quite sure, Judge. I apologize.
We'll make it so if it hasn't been. But then to continue kind of the prologue here is that we received a response back from Fulton County, kind of point by point, saying how many man hours it would take to comply, and it was substantial. And in the thousands, if not, I think tens of thousands of hours, 57,000 hours on some of these issues. And so I think where we left it is very much that we have contested issues of fact. I don't know if these are going to be solved by way of proffer. And so I think at this point, well, let me start there. Anything we need to add before we get into it in terms of the lay of the land? Let me start with, I'll start with Mr. Kachuroff just because you're standing up here.
Okay. I would propose that we go through them. Some we can go through pretty quickly. Some I can agree with. I'm not going to nitpick over an hour here or 2 hours there. I think I can add some clarity to why there's no need to put 37 years of manpower into what should have been done in one day on November 3rd, 2020.
Okay. So at this point, you think we can still just kind of go through this in almost a mediation style? We don't need to have a witness here telling you exactly how something's produced and in the manner?
I agree, because a lot of this stuff, believe it or not, I have served as the basis for our response to the motion to quash, which were open records requests, but some open records requests have certifications, others don't. And I think that I can add clarity to each of the requests and their corresponding time estimates, and whether the time estimates are incorrect. And I think it'll make sense.
Okay. Well, I'll do it. I'm optimistic that that's the case. I will say the caveat is I don't know the nuances of how ballots are collected and counted, and I think you have done, you're studying on these things. So for me to grasp exactly how these are collected and the processes behind them, we may need to lay out more so we can really understand that. But we'll see how we go. Mr. Alexis?
Judge, I just want to put on the record that we're not a party to this case. We're just here to address the subpoena. We don't have a dog in the fight. Aside from the relevance issue, our only contention is that this is burdensome and oppressive. We're in the middle of a federal election. To that end, Judge, we do have two witnesses here who the court can make inquiries to, but I do agree that a mediation style approach may be best because, again, as non-parties, I'd hate to subject my clients to being grilled and cross-examined.
And who are those two witnesses you'd have?
We have Mariska Bodison and Derek Gilstrap, and Your Honor, ordinarily we would have our directors and leadership come in and testify, but again, we are preparing for a federal election.
Sure.
I can have them stand and introduce themselves.
I think for now, if you could just let me know what their respective titles are and what they would be testifying to generally.
Adler. I get shaky on their title. So let me just.
Or just generally what their job roles are, why they're here, why they have the expertise.
Mr. Gilstrap is in IT. He does the tech part of elections department, and Ms. Bodison, she's the executive assistant to the BRE and for the elections department.
Okay. All right, so turning to the amended subpoena with the additions provided by Fulton County with the time estimates. And page 3, we have items to be produced. Mr. Kucherov, I think you offered to kind of just take the lead on this. I'll just let you have the floor.
So for the first item, user manuals, 4 hours. No disagreement. The issue there is, I talked to my colleague ahead of time before the hearing, trying to work some of the things out. Probably should have talked more with him. But he said those are in a warehouse, in a box, and so they have to spend time to go get them. I suggested, well, maybe Dominion can provide those user manuals that were in use at the time via PDF. The option was, well, you can subpoena Dominion. Well, I didn't want to do that because if I subpoena Dominion, then the response might be, well, those weren't the ones that we had. So I was hoping that we could short circuit some of this. So, I mean, some of it is what it is. I'm not going to argue about number 1. Number 2, an election equipment inventory. They should have a list of these things. I don't understand why it would take 24 hours to pull up lists with all of the different machines and what the serial numbers are on the machines. You would think that there is an inventory somewhere in a file. We're looking for digital production. I'm not looking for new copies of what was in existence in 2020.
What if, this is where we might have to pause. I'm reminded of the open record standard, which is they're not obligated to go out and create documents for you. If they're going to sit here and testify today, is that they don't keep that list and that they would have to go around and actually make you a list. What happens then?
If that's what the answer is, the response, they don't go around keeping the list, then they don't go around keeping the list. I accept the response. But I just want to know what they have and what they don't have.
All right, well, let's start there. Item 2 on the items to be produced.
Your Honor, if it might be easier for my colleague and myself, if you want me
You
to
can just
argue
remain seated, that's fine. Just make sure you get that microphone very close to your mouth.
Is this the one that you said? Okay. Judge, a lot of this information is in hard copy. And pursuant to election code, it was submitted to the clerk, and it is in that warehouse that opposing counsel just mentioned. So to actually go and get this information would require employees to go to the warehouse and rummage through the boxes and pallets to try to find the information that's needed. And from what I understand, we're looking at about 100 pallets with maybe 30 to 45 boxes per pallet. And because they've been moved so many times, there's no way to determine what sort of, format they're in. They're not arranged in a particular order, so for us to actually go find it, it wouldn't take 5 minutes, Judge. And that's why we put the 24-hour time period on it.
And it sounds like that's a similar process to what you were going to need to do for user manuals. So why the difference between the 4 hours and the 24 hours?
Well, I think it's because we're looking for more information in number 2 as opposed to 1.
Okay. And Mr. Kucherov, feel free to respond to that, but I'm also wondering too, I guess as we go along through here, accepting for today Mr. Floyd's relevance solely for discovery purposes. We're not saying that this could potentially be relevant at trial. That's another bridge to cross when we get there. Why is this particular aspect of your request relevant to essentially auditing the election?
Because part of the audit process requires taking the inventory of the system that created, for instance, the poll tabulator tape. It shows you security. Is the election secure? Were the machines that were said to be used actually used? And it's a way to match up serial numbers from machines and devices to other types of reports.
All right, so once you've got serial numbers for all these devices, you're saying you can then compare that to something else?
A number of things. For instance, the logic and accuracy testing to see which equipment was tested and which equipment was not.
Okay, and more to, in response to what he added.
I'm not going to argue about the 24 hours. If they think that's their time estimate and it's in the warehouse, I get it. So 1 and 2.
All right, and we'll move on to number 3. We've got 688 hours listed for, I guess this is still part of item 2, rather. 688 hours for election equipment with test results. This is all the tabulators and...
Actually, Your Honor, it's the logic and accuracy testing. We're literally looking for the test results for all the things that have serial numbers. So I would think that they could all be produced together. I don't know how they keep it in the boxes, whether they haphazardly throw them in the boxes with ballots. I would think there'd be just a couple ballots, or a couple boxes that have administrative items in them that they could pull from.
Okay, so what can you tell us about the logic and accuracy testing results?
So the bulk of these hours come from the poll tapes, and we're looking at about 656 open tapes and 656 closed tapes. And each tape is about 12 feet long. Of course, if we're handing over information that, or I guess documents that they would produce in evidence, we'd give them a copy. So for us to actually copy the tapes, we'd have to put them on the printer piece
Well,
by
y'all have already surpassed what I'd warned you about, which is when you say tape, I have no idea what you're talking about. I'm thinking of videotape. I don't know.
Oh, you want to explain what the poll tape is?
Tape produced by the scanner tape that's produced when we do
This is Mr. Lohman.
LNA testing.
Actually, this person doesn't identify themselves for the record.
Sorry.
Yeah.
My name is Jerry Gilstrap. I'm
Okay.
election system supervisor.
All right, great.
Fulton
And
County.
you were explaining to us what it means to have a poll tape. What produces it and what's it look like and all of that.
The poll tape is produced from our scanners, our tabulators. They produce the poll tape once we run the ballots from our LNA testing through the scanner. It produces a tape of all the results from those ballots.
So it's not like a digital file. I'm picturing a movie reel. This is something like that, like a wound tape on a wheel. Again,
It's like a calculator roll of tape. It's like like you have a cash register and the tape produces once you
okay.
once you buy something.
So that does sound like something. It's not they're just picking up and copying it on a hard drive. This is something physical that they have to then make into another format, and that takes time.
That's true, but 688, I don't think 688 hours. And the reason why I say that is because a Fulton Records, an open records request dated December the 1st, 2021, provided tabulator poll tapes for the 11/3/2020 election, including those that were used for advanced voting and logic and accuracy testing. So they actually should have these scans already done, first of all, and I think that would be, and I've got the open records request number.
Here, let's start there. Has this already been produced in some format to somebody?
I can't speak to that, Judge. I really can't. If it has, I can go look at it. But I can tell you what the process is, and we got this number based on what they have done in the past when they had to give the information to, let's say, the SOS, and basically you put it on the printer and you print each portion of it. And because it's 12 feet long, you have to close the copier, open it, move it to the side, close the copier, open it, move it to the side, and that takes about 30 minutes per tape. So if you have 656 tapes and you're printing and you're doing 30 minutes per tape, Judge, and you're doing that for open and closed tapes, you're looking at 656 hours.
And let me add to this. We're actually looking, if you read one of the things we're looking for is the actual LNA report. itself, it has the testing results on it. That should not require more than a couple of hours to copy that. And I don't understand how we get 688 hours. I don't even know what the poll tapes are, and they're 12 feet long, but it doesn't take 30 minutes to copy a 12-foot long receipt, essentially. So I don't think 680 hours is appropriate. And I will remind the court, Mr. Floyd is looking at 37 years, and they're claiming it's going to take more time than the amount of jail sentence that he's faced with at this point. So I don't, all this should have been done on November 3rd.
What are the total number of roles that are at issue here and to satisfy this? How many pull tape rolls are there total?
656 open and 656 close.
And how does one get open and how does one get closed?
No, well, one's called an open tape and one's called a closed tape. So they do the open tape at the beginning of the election and they do the closed tape at the end of the election.
And the subpoena asks for both.
Yes,
You said it was 656 open and how many are closed?
and 656.
Okay. And each of these are 12 feet long?
Yeah, about 12 feet long, yeah.
So there's only over 12,000 of, excuse me, not 12,000, 1,200 of these that they'd have to be copying.
I can buy the scanner for the county. Scanner will cost me about $400, and I'll have each one can be scanned in about a minute.
The county will appreciate that.
Okay? if that's going to be the solution, sold.
Well, so there's a special scanner that you don't have to then do each foot by foot by foot?
Not that I'm aware of, Judge. I
But
don't.
you have one?
Yes, Your Honor, we can supply one.
Okay, well, again, I think these are things that the two of y'all know more about this than I do. I don't know what value I'm adding to this, but we can keep going in this manner. It sounds like, again, something that could have been solved through an email.
I'll make this easier for my colleague. I know he wants, you talked about this earlier. 4, 5, 6. Or I should say, requests 4 through 11. There's no argument on.
Does that include, just because since I see the labeling, there's a 3 on the top of page 4.
No, that was the LNA testing. That was part of the LNA testing. What I'll do is I will provide a scanner for the county, but I want it back.
I'm just trying to make sure I'm accounting this right. So the top of page 4, there's labeled paragraph 3 underneath election certification packet.
Yes, yes.
I'm looking at the amended subpoena. Are we on the same page?
I think so. I have so the election certification packet section,
Okay, yeah.
election night reporting webpage, chain of custody, no disagreement.
Okay.
The ballot images, which is the next section, I do quibble with that because they already have it in a zip file. They sent all this stuff, I'm sure they've sent this stuff to the SOS, Secretary of State. So I don't understand why 24 hours, when they don't need 24 hours to look, unless they have to go look for it. But I would think that that's on a computer hard drive or something that they could just zip to another.
Okay,
The images, they have to be copied.
So moving on, we're now on the bottom of page 4 of the amended subpoena with responses, ballot images, where I think the county had replied back 24 hours. Any insight on that?
Okay, so Judge, in review of this request, we did state it as 24 hours, but it should have been more an overnight run, and that's because we actually have to, I guess, fire the system up and let it run overnight, so it's supposed to be a one-day turnaround, but it ended up getting logged in as 24 hours.
Okay, so I think what we actually need to reflect is the man hours, because that's what they're going to have to cut you a check for, right? So what are the man hours to get the ballot images to you?
And Judge, we can't run both systems at the same time, the original count and the recount, so it'll have to be done separately, and that's, I mean, we do it overnight one day and then overnight the next day.
Yeah, and I don't think the time's so much our focus as what the man hours are and how much, they owe you.
Okay. Can I confer? Judge, the actual work itself, 2 hours, and then it'll just be a matter of the system populating the information overnight.
All right, so ballot initiatives revised estimate of 2 hours. Any issues with that, Mr. Kuchera? Okay, seeing none for the record. Moving on, tabulator files and reports. The heading, this is listing 2,866 hours. I think mainly because it's saying it doesn't exist in the format requested.
I'm saying.
Any initial reactions to that?
Judge, we made a few modifications on this as well.
Okay.
So for 14A, we don't have the information requested in that format. 14B, it will be much like the last one we just discussed, wherein the system will have to be fired up and run overnight. So that's why we have the 8 hours. Now, the man hours itself would probably be an hour. As for 14C, we're looking at, because we have the open poll tapes, the status tapes, and the closed tapes, we're looking at 1968 tapes. At least it's okay. Oh, the LNA tapes. Okay. So we're looking at 1,968 tapes, and at 30 minutes per tape, that's 984 hours.
Is this the same issue as before, that the bulk of this time is because of scanner limitations?
Yes.
All right. And so potentially that is going to be dramatically lessened if you have better equipment?
I mean, if this equipment exists, yeah, I will agree with that. I mean, and one thing I just want to, I guess, keep in the court's air is that we do still have to go in the warehouse and locate this stuff. So.
Right. Well, I mean, that's reflected in the hours. I don't think we can quibble with that. But.
Okay. And as for number 15, we will have to contact Knowing to get that information, and once we do that, we're on Knowing's time. For the
You say that again. The what time?
Knowing, that's a vendor. I'm sorry, Judge.
So is this something that's not even in your possession?
It's not.
Then I don't see how you could respond to that subpoena.
All right.
We couldn't probably get the material without permission from the county to obtain it from, what you said, Knowing?
Knowing, yes.
Well, I think a vendor would have to respond to a court order for a subpoena.
Right, so I'm going to go ahead and send a subpoena out for, that's the tabulator poll closing tapes?
Number 15.
My numbering is off, I'm sorry.
Copies of all tabulated poll closing reports and tabulated reports generated by each precinct and polling location.
Yes, okay.
Got it?
You need to make sure you're talking to the microphone. Our court reporter's having some trouble. And just I'll just state this for the record. Any conversations between counsel, we're not going to have those on the record. Okay? So, you were going down the list here. I think you still had, it sounds like bottom line for the entire section listed tabulator files and reports, where originally the estimate was 2,866 hours. That's largely driven by copying limitations that may be remedied through upgraded equipment. Is that fair?
Yes, Judge.
Okay, so we'll flag that. I think where we're getting with this is, assuming we can make it through all this, is that the parties are going to need to, again, direct them to confer once more, and I'll need an updated and revised time estimate in a week or two. We'll talk more about how much time that's going to take. All right. Election management system, EMS. County's estimate was 72 hours. Is there concern with that from Mr. Floyd?
No, Your Honor.
All right. Backup copies of hard drives, SD drives, and USB drives, county estimated 16 hours. Any concerns there?
Which number, Judge, my numbering is off, I'm sorry.
So I tried to start just looking at headings now instead of the numbers.
Backup copies of hard drives.
Right.
I don't think the county, maybe the county can elucidate on this.
It said
It didn't have the original format was not an in-case format. And maybe since our tech guy is here, when we say in-case format, we're basically talking about a forensic image, which is a standard in the industry. And that copies everything on a hard drive, including the empty spaces, without impacting the integrity of the drive. It's a mirror.
Yes, Your Honor, we cannot produce those. We're not able to produce those
in that format.
in that format.
And why not?
Basically, our system will not allow us to produce those. I mean, they may be able to get that from Dominion or the Secretary of State. They may be able to produce those, but we cannot produce those.
All right, but in the format that you could produce them in, was that part of the estimate?
Yes, sir. Yes, Your Honor.
Okay. All right, with that proffer,
Sorry, I didn't hear the last part, Your Honor.
he was saying that they can produce them, but it has to be in a different format, and that's what accounts for the 16 hours.
I mean, if that's what they have, it's the original 16 hours in the format, without making an image of the actual drive, I'll take it.
All right, moving on, reports and logs, they list 4 hours for that.
No objection.
And then we have lists of several items.
No objection.
Okay, and that's, they say number 25 through 41 for 24 hours to produce that. We have oath documents, which they say will take 6 to 8 hours to produce.
I don't, like I said, I don't try not to be picky, but 6 to 8 hours for documents that basically show somebody took an oath. I don't maybe I misunderstand, but it seems that that's a pretty quick one in a folder.
Are those all kept in the same place, or are those scattered about?
Warehouse, Judge.
So it's in the warehouse. Are these boxes labeled, or are they just...
I can't speak to what the format of the boxes are right now, but from what I understand, they're not in a properly identifiable order.
Well, that leads me to have less confidence in these estimates of the... If we have no idea where they are in the warehouse or the status of them or the state they're in, how did we ever arrive at 6 to 8 hours to begin with?
Well, Judge, we were trying to give conservative estimates because we do want to work with whomever. You know, again, we don't have a dog in the fight. You know, we just believe that if we, I guess, did a diligent search, that we can come up with this information within that time period.
Okay.
I do say, hey, it's about 90 to 100 pallets, but again, it's still only 90 to 100 pallets, so 6 8 hours may work.
And again, I'm trying to draw on kind of open records experience where often in response you give an estimate, and if it's actually less time is spent, the ultimate bill is less, right? Or you get halfway through and you start warning the other side, hey, it's actually going to be higher than we thought. Do you want us to keep going? I think that's what we're going to have to do on this as well. And we can do this in stages. And, but I also think part of this is going to have to be paid up front. We can get into all these things. I think these are some things that the parties can negotiate and get back to me on. But I just want to flag these issues for y'all. It sounds like that's something that on the oath documents, let's take another closer look at that in terms of what we think the state of the warehouse is, and actually how long it takes to drive over there and find that box, if they're all in the same box.
Okay.
Okay, signatures, absentee ballots, envelopes.
Envelopes, yes, Your Honor. So we're looking for the outer part of the envelope. The estimate was 57,000 hours. And I think maybe...
Well, we started, I think, I know that's the heart of it, but let's start with, I think paragraph 43 says the outer I'm trying to make sense of this. Under the heading, I've got 72 hours unredacted, 150 hours redacted. Is that in reference to something different than the 5,700 hours, 57,000 hours?
Yeah, so the signature exemplars, that's the 57,000 hours, and the absentee ballot envelopes, that's the 72 hours.
Okay, let's start with the envelopes. And remind me, what would be redacted if they are redacted? What would be unredacted?
Okay, do you want to explain the envelopes?
And if you could identify yourself for the record.
Yes, sir. Mariska Bodison, the executive assistant and the board director, board secretary, excuse me.
And so, what needs to be redacted off these that effectively doubles the time to produce them?
On the oath envelope, there is the date of birth.
Okay.
I couldn't hear, I'm sorry, Your Honor.
Date of birth.
Oh, date of birth.
And Judge, if I can just give an explanation as to the redaction process. So usually when we make a copy of something, we take a magic marker, we'd strike through. But usually if you hold that paper to the light, you can still see some of the information. So what happens is that we have to then make another copy and possibly redact again. And that's what causes the extra time.
Because your plan is to produce these in physical form? You're not just going to send them in a PDF?
Well, the envelopes themselves, they are in a physical format, and you actually have to do them one by one because they're used envelopes. So if you try to scan them in batches, they will just jam in the printer.
Okay. What do you think, Mr.
Yes, so this is where I think I could short circuit this tremendously. I think my understanding from talking with my colleague earlier is that the Blue Crest sorting and signature verification machine was not operational. So I didn't really want new scanned images. I wanted the existing scanned images that were done on November 3rd for purposes of signature verification. So my understanding is that did not occur because the Blue Crest verification machine was not working for the 2020 general.
Judge, I'm not commenting on that.
If you go this way, it takes you the short way. Yeah.
All right, we've got someone.
I mean, it's not that much fun.
Do we know who that is? Okay. Mr. Alexis.
I'm not commenting on whether or not the Blue Crest machines were working. We didn't use the Blue Crest machines at that time period.
Okay, so if the subpoena as intended by Mr. Floyd is for the any images produced by this machine on this date, your response is you don't have any in your possession.
That's correct, Judge.
So they're.
Go ahead, can you see?
Give me a second, Your Honor.
Sure. Not from you.
I can have my tech guy appear on site under the tech supervision, write a script that can, once we scan all the files, we can have a script that automatically blocks out the date of birth. Because that is PII under Georgia law.
Well, we still have to
Well, we're jumping back in time to the envelopes.
Right.
So on the envelopes, you're saying that you think you have a more efficient way to redact them.
Correct. I have a more efficient way, but my colleague is saying that they didn't do signature verification using the Blue Crest sorting and signature verification machine?
Correct.
Okay. And so...
Is that solely the 57,000 hours estimate?
I'm sorry, are we on to the next one?
Oh, we hadn't gotten there. Okay, we're still just on the 150 hours.
Yeah.
Okay. And is that where the Blue Crest becomes relevant? I'm looking at Mr. Floyd's team.
Oh, okay, I'm sorry.
Yeah.
Your Honor, the Blue Crest sorting and signature verification machine would take the ballot envelope and scan it and create an image of it. Image appears on screen with a signature exemplar, and the two are compared that way.
Okay.
So my understanding is now the Blue Crest sorting and signature verification machine is not working, or
No, we didn't use it.
They did not use that.
Not use it.
So for the item you're requesting to obtain for the scans of all the outer envelopes, they would have to rescan those again, is what we're hearing.
Well, it sounds like they were never scanned to begin with, and so I don't know. Unless
So
if they were scanned, I want the scanned version.
Right.
That they had on that day.
So are there any documents in the county's possession of these items having already been scanned?
Not that I'm aware of, but I can check at headquarters and see if they do have it.
Okay, so the difference here is not so much that there's a total new rescanning, it's what was scanned and is still in your possession from that date.
Well,
Are we making the distinction here?
Nothing was scanned, Your Honor.
Okay, so we're absolutely clear. We're talking about the outer return envelopes in November 2020. Okay, so where does that leave your subpoena requests?
I think, Your Honor, if we can put that to the side, like this, as an item for me to work out with the county, so I understand exactly, because I was under the impression that they had a sorting machine that did all that. So if that signature verification process was not used, I just want to be able to see what, so I can, when we do our audit, we can look at it and say, okay, this is what was done. I'll see whether I actually need those or not. I'm not sure at this point.
All right. Takes us on, does this now take us to the signature exemplars and reference images, or is that the same thing?
this takes us to that new section, Judge.
The signature exemplars is under the same section.
Same issue.
Same image, yeah, but no, it's a different image. It's a separate image from the ballot envelope image. One is signed on the back.
Okay.
Use that. So
this whole section, you're setting that aside for now?
yes, I'm setting that aside.
Okay, then that takes us to absentee ballot application forms.
Actually, no, I'm sorry. I apologize. We do want 45, or number 44, the provide all signature exemplars and reference images for all registered voters.
Okay, so that is the 57,000 hour response. And
actually, Judge, it's just the signature exemplars. Those are digital. That should be another copying of a digital file, a massive file.
So, Judge, we do not have a file of simply signatures. We actually have them in different databases for different voters. And we're looking at 860,000 voters. And we have two different systems that we have to look in to ensure that we do find a signature, because if it's not in one, it could be in the other. So at 860,000, and let's conservatively say we can check each system in 2 minutes, we're looking at 4 minutes per. So 860,000 multiplied by 4 minutes gives us 3 million plus minutes. You divide that by 60.
okay, a lot of time. So what is it that you're doing in those 4 minutes exactly per voter?
We're going to check one system to see if we can find a signature, and if it's not there, we'll check the other system.
And why do we need to check either system? Why not just have both if we think they're in there somewhere?
I'm not following.
So as I'm understanding it, there's just a general database that has all these signatures in it.
Well,
Why do we need to cross-reference them?
No, it's not a database of signatures. We actually have to go into the database and find the voter and look at the information and search through and find the signature wherever it may fall. And then when we get that, we, I guess, export it somewhere, have it printed, and if it's not in that database, we go look in the other database to find it.
So essentially you have a database with each voter as its own folder or file in some way, and to go in and pull out the signature image, that's what's taking the time?
Yes, sir. So for each voter, I would have to put in your driver's license number or your voter registration number. I then have to go to your profile to see if you actually have a signature on file. If in the registration database, Georgia's registration database, you don't have a signature on file, we have an in-house electronic database that we scan documents into, and we check that. There are no guarantees that we'll have all 860,000 signatures. The hope is that we will.
No, we're not looking for 860,000. We're only looking for the absentee ballot signatures at this point.
You said all registered voters in
Yeah.
your request.
I'm sorry, I'm still stuck on number 4.
On which one?
See, let me-
Well, I thought we'd moved on to 44. You'd said 43 was, you needed to double check about the machines and the signature verification audit. We were looking at 44. That's the 57,000 hour request.
Right. Okay, so 44 and 45, if I can put that to the side to talk, I think I can work that out with them. So I understand the process. I don't want to delay this anymore. I think we can get through that.
Okay.
And I can work with the county's IT person and my colleague and get a solution for both of those together.
Okay.
Because maybe I just need a certification from the county that we didn't do signature verification.
Well, I don't know if you're ever going to get a certification because I don't know if that's allowed through the subpoena process. I mean, you could always call them as a witness, or if they want to voluntarily give you a certification, great. But again, what is being asked of this court is whether to enforce the subpoena, and that's what I'm trying to focus on. And that is whether documents are in their possession or whether they're not. And I think that's taking us closer to the end. The last thing we have is hardware and networking with 32 hours of work.
We skipped one, I believe, Judge, the absentee ballot application.
Oh, well, I thought you said 45. I think that's about our numbering being off again.
Yeah, I'm
Okay,
sorry.
so absentee ballot application form, 10,000 hours redacted.
Yeah, I can have my tech guy show up and write a script that automatically redacts it, and you can hold it up to the light all day long, and you won't see the date of birth. The only thing on it, and I have a 2020 application here, the only thing on it that is PII is a one line that says date of birth. So,
Okay, if I could get the county to walk me through their thought process here.
So on the application from 2020, there is the date of birth, their email address, their phone number. Yeah, so there's actually multiple areas that you're required to redact.
Your Honor, under Georgia law, the only PII is the date of birth. Nothing else is PII. Now, we don't intend to go publish this. We're not going to publish this. This is for our...
I mean, there would be a protective order no matter what we do
Correct.
with this.
Correct.
And then we can go into the details of what that would look like. I think we've already expected here that the parties need to continue their conversations. Here's what I would ask to add to the agenda is that you'd be outlining exactly to the county the process and how you're planning to review this, who would be involved, and then I'll let the county make the initial decision of whether they think that's adequately protecting the date of birth, if that's something we need to come back and clarify. And that's something you could also make preconditions of and ask or suggest what else could be done. Again, I'm trying to encourage the parties to find the middle ground here. But the bottom line, if it's assuming it's unredacted and the county decides to take you up on this offer of software, I'm not saying they have to because they might not be comfortable with whatever this program is you're proposing. This unredacted, the 460 hours, where does that come from?
So, Judge, we have, and I think that number could be, we have 470,000? 470,000 absentee ballot applications. You do them in batches of 150 at 15 minutes per, I will start racking up at that point.
Yeah, okay. So basically you're saying you have to pull these one by one, or these aren't something that can just be pulled in mass?
No, we can pull them in mass, but when you have to feed them into the printer, you can only feed them in so many.
But when you say you're pulling them in mass, can you just save them as a digital file? Do we have to print them all?
Oh no, they're in physical format. They're in physical format.
They are currently in physical format.
Yes, Judge.
Well, so I understand that some would have been done online, that you could do your online registration as well, no?
If
You don't have to write this.
they were, 1 second, Your Honor. Judge, if they came in emails, we'll have to be combing through emails to find the applications, but all of the applications were printed.
I'm still getting the impression just generally here that we haven't placed our finger exactly on what it is that's being asked and how it could be produced and whether it's the most cost-effective way and whether there are alternatives. And so the ultimate point, I know we still have one more section to cover, but to the, just like the previous two sections, it seems like we're still not ready to make a ruling if I need to make a ruling. And what I would just go ahead and say at this point is I would propose, again, directing the parties to address the issues we've covered today and some of the points we've brought up, that by February 2nd, that's 2 weeks from now, that we have a little more guidance that you can provide me perhaps with an amended subpoena and maybe more narrowly tailor the time estimates. And again, I think more of an exchange of information is going to reduce a lot of time on the back end of what needs to happen. And I think what you're also going to need to do as well is start putting those hours into a cost, exactly what is it going to cost per hour as well, right? Okay. And if there's equipment, again, I would encourage everyone to find ways that if there's a more efficient way of doing it, digital or otherwise, that we do that, and it's not just the longest way possible. So if there is a type of piece of equipment that can make it more efficient more quickly, how much is it going to cost to buy that piece of equipment? If he can identify you a scanner and it's $10,000, maybe you buy that scanner instead of saying it's going to be 20,000 hours, right?
Well, I mean,
and no, I'm not saying you buy it because he's going to pay for it. Okay.
I want it back.
Well, we'll see. That's what I'm clarifying is that when you're making the bill, we can do this in a way that.
And Judge, the fact of the matter is that a lot of the stuff from 2020, it's just all in physical format. Things were done a lot differently back then.
Back then.
Hey.
It's not that long ago, right?
Listen, COVID has changed.
Okay.
Has changed the whole time perspective. And a lot of things have changed in Fulton County elections and how we, process information and store information. So, we're just sort of stuck in that regard.
Okay. Understood. And so I think that's why we're having to work through so much, and I appreciate y'all continuing to do that. But I think that where we stand now and the demands of this case, that we're going to need to still work through those.
Fair enough.
Okay. So I'll wait to hear back from you another report on 112. In a perfect world, maybe y'all have come to terms and something along the lines of what was presented from the Secretary of State's office and the GBI with the protective order agreed to by the parties, with the amended subpoena made part of the record, with the terms and conditions, with what payment is to be conveyed and when. Again, with some of these ideas in mind, how much up front? There are going to be steps along the way where you pause and give them updated estimates, all those kind of things. These are things you need to think through.
Okay.
What else do you think we need to discuss today?
Yeah, and that's going to be, just saying up front, that will be difficult as we are prepping for a federal election.
We have all the time in the world. We're not rushing anything, so I want to get it right.
Sure. So if after 2 weeks you're still stuck, you think you need more time, let me know, and then let me know how much more time you need.
Yes, Judge.
Okay. What else?
Nothing from us.
Okay.
It's been great, Your Honor. I appreciate the opportunity to talk to them before, and I didn't realize the tech guys were here. I would have had at it.
Okay. Fair enough. I'm trying to. I'll try to avoid what happened today, where we just got really behind schedule, but I am trying to prioritize getting some of the other hearings.
Judge, if I may say, generally speaking, if we can have schedules where we have our brief, you got your motion filed, you got your memorandum of law, like I want to do in one state gets its opportunity, and then we get a reply, and then it's set for issue. We do the hearing. I think that's much more efficient and less costly on my resources and even the court's resources, because going back and having additional hearings back and forth is.
No, I think that's a fair point. I never know. Unlike federal practice where it's just assumed someone's going to file a response and reply.
Right.
That's not generally what we do. It's just if you want to.
Right.
And so I haven't really stepped in and required it yet because everyone seems to elect to do it. So if that's going to continue to be the practice, then I think all we need to make clear is what the expectations are from the parties. But I mean, generally, when you file the motion, that's considered step one, and I know you still want to file a reply,
Right.
and so we can allow that. So I guess what I'm hearing from you is you think that the 26th is too tight a turnaround for that?
Yes, Your Honor, and I think there's other, I mean, the state is not here, so I don't.
Right. No, we're just talking logistics.
Logistically speaking, there's other matters in the docket that I think need to be heard first. The February 15th matter is going to be heard. I didn't think much of it until just a couple of days ago, but that would be something that I would want to have heard first before my motions are scheduled.
Well, I don't know if I can promise that, just because I'd kind of set aside the week of February 12th, just try to have as many hearings and motions as we can. And since the latter half of that week is devoted to that motion, I still want to utilize the 12th, 13th, and 14th, just as a heads up. But we can continue this discussion with all the parties attached through email.
Okay.
All right.
Thank you, Judge.
All right, we'll be off the record. Thank you, everybody.
Will we be released, Your Honor?
Who's not released? Oh, well, we're off the record. We are adjourned.
I'm released, Your Honor.
Okay.